Assalamualaikum and hi everyone, and thank you for being here. We are pleased to present on a very important piece of legislation in Malaysia, the Employees Social Security Act 1969. Our group consists of 4 members, which are NOOR YASMIN HANI binti AHMAD, NOOR SHAZIRA binti SUHAIMI, IRDINA NATASHAH binti AZAN, and my name is Fatin Nadvella binti AZMAN. As the first presenter, I will cover 2 key areas, the purpose of the law and the scope of employees covered under the Act. The purpose of Employees Social Security Act 1969 is to provide social security protection to employees and their families against work-related injuries, occupational diseases, invalidity or death through compulsory contributions managed by SOCSO. Also, this law is to provide comprehensive protection through 2 primary schemes. First, the Employment Injury Scheme, which covers workplace accidents, occupational illness, and even commuting incidents. Second, the Invalidity Scheme, offering round-the-clock protection in case of permanent disability or death. These protections are funded through contributions made by both employers and employees, ensuring essential social safety nets are in place. Now, let's talk about who is covered. First are employed workers included under this Act. There are Malaysian citizens and permanent residents working under contract of service or apprenticeships in the private sector, as well as temporary or contractual staff in federal or state government and statutory bodies. Also covered since 1 July 2018 are spouses of enterprise owners. Contributions are calculated based on monthly wages, capped at RM6,000 Malaysia, effective on 1 October 2024. Not covered are permanent civil servants, most self-employed people with the narrow exceptions, and owners operating as sole proprietors or partners. Second are foreign workers with valid passports and work passes that have been covered under the Employment Injury Scheme since 1 January 2019 and under the Invalidity Scheme since 1 July 2024. Employers contribute a combined 1.75%, include 1.25% EI plus 0.5% invalidity, while foreign employees contribute 0.5% for invalidity. This ensures access to medical treatment, income support for disability, funeral benefits, and repatriation. Third are domestic workers from 1 June 2021 that are included under ESSA 1969. They are defined as individuals employed exclusively within a private household, such as maids, drivers, gardeners, cooks, caregivers, or nannies. Local domestic workers, which are Malaysian citizens, PRs or TRs, receive the full range of benefits, such as employment injury and invalidity, while foreign domestic workers are covered by both schemes since 1 July 2024. Contribution rates are employer 1.25% EI plus 0.5% invalidity equal to 1.75%, local employee 0.5%, and foreign employee 0.5%. To sum up, employers must register all eligible workers via Perkesos Assist portal and submit monthly contributions. Non-compliance carries penalties of up to RM10,000 in fines, 2 years imprisonment, or both. With that, next, I will hand over the presentation to my teammate who will explain the employer's legal obligations under the law.
Next, I will explain about the employer legal obligation under the Social Security Protection under the Employee Social Security Act 1969. This Act mandates employers comply with specific duties to ensure employees are protected under the Malaysian National Social Security System administered by the SOCSO. The first legal obligation is to register company or industry with SOCSO. According to Section 4, every employer whose business falls under the scope of the Act must register the company within the time and manner specified by the regulations. This step ensures SOCSO is aware of the employee operations and can monitor compliance with contribution requirement. The second obligation is to register all employees under the Social Security System. Under Section 5, Subsection 1, all employees regardless of their wage level must be insured by the employer. This registration activates coverage for the employee in the event of occupational injury, disease, invalidity, or death. Third, employer must deduct the employee share of the monthly SOCSO contributions from their wages. As stated in the Section 7, Subsection 2, this deduction must correspond to the contribution rate set out in the third schedule and must relate to the wage period which the deduction is made. This ensures that the employee contribution is collected legally and fairly. Fourth, employees are legally required to contribute their own portion in addition to the employee share. Under Section 6, Subsection 1, the total contribution comprises both employer and employee shares. It is important to note that Section 7, Subsection 2 that the employer's share must not be deducted from the employee wages. This is a direct cost borne by the employer as part of their duty of care. Fifth, the employer must remit both contribution employee and employer shares to SOCSO by the end of the month. As outlined in the Section 6, Subsection 8, contributions are due on the last day of each month. If the payment is delayed, Section 14A states that the employee is liable to pay interest on the overdue amount. Thus, timely remittance ensure continuous protection for the employee and help the employer avoid penalties. Lastly, employer must report to SOCSO any occupational accident or disease affecting to an employee. Under Section 26, if an employee dies to a work-related accident, dependence benefit become payable. Hence, timely reporting is crucial to enable SOCSO to initiate benefits and support for affected employees or their dependents. These legal responsibilities are vital to safeguard the right and welfare of employees, while ensuring employer compliance with national level law.
Next, I will explain regarding types of Social Security benefits. This Act provides essential protection to employees through two major schemes, which are the Employment Injury Scheme and the Invalidity Scheme, that are divided into three categories, which are for employed workers, foreign workers, and domestic workers. Let's begin with protection for employed workers. For Employment Injury Scheme, this scheme provides protection for employees against accident or an occupational disease due to work-related incidents. It covers work accident, community accident, emergency accident, and occupational disease. The key benefits that included in this scheme are medical benefit that provide medical care for employees who suffered from employment injuries or occupational disease, where employers or employees also can claim for reimbursement of expenses incurred for treatment if it is received at Perkeso non-panel clinic. Then there's a temporary disablement benefit for employees who temporarily disabled, such as having bone fracture on leg and is on medical leave, which being paid by 80% of the employee's average assumed daily wage. Permanent disablement benefit also being provided for employees who suffer from permanent disability due to employment injury, such as eyesight or hearing loss. Next, there is a constant attendance allowance to help employees who suffered from total permanent disablement and is so severely incapacitated that require personal attendance from certified person that recognized by medical board or special medical board or the appellate medical board. Physical or vocational rehabilitation also provided to support recovery and help the worker return to employment through physical and vocational rehabilitation that will be borne by Perkeso. If an employee dies as a result of an employment injury, his dependents are entitled to dependence benefit by 90% of the average assumed daily wage of deceased employee. In addition, funeral benefit with amount of 3,000 ringgit will be provided if the employee dies as a result of employment injury or while in receipt of permanent disablement benefit. Lastly, education benefit in the form of loans may be provided to a dependent child of insured person who dies as a result of employment injury or is in receipt of periodical payment for permanent disablement benefit. Now, moving on to the invalidity scheme. This scheme provides coverage to employees who suffer from invalidity or death due to causes not related to their job. It includes the invalidity pension, a money payment to support the individual who have been certified invalid by the medical board or appellate medical board and not attained 60 years old at the time invalidity notice is received. Next, invalidity grant, which is a lump sum for those who don't qualify for the invalidity pension, is also provided. If insured person who has been certified and is so severely incapacitated require personal attendance from certified person, constant attendance allowance is provided for 500 ringgit per month. if employee dies due to non-related employment cause before attained 60 years old, or the employee who received invalidity pension dies regardless of his age, dependents of the employee will receive survivor's pension. Next, physical or vocational rehabilitation and dialysis are provided, where all expenses incurred for the rehabilitation and dialysis will be borne by PERCASO. In addition, funeral benefit with amount of 3,000 ringgit will be provided if the employee dies due to any cause. Lastly, education benefit in form of loans may be provided to a dependent child for an insured person who dies while receiving invalidity pension or dies before attaining the age of 60 years old, but has completed a full or a reduced qualifying period or is an invalidity pension recipient. For foreign workers, the protection provided is almost fully similar to employed workers, except of several benefits, where for the employment injury scheme, only physical rehabilitation facility is provided and no education benefit is provided. In addition, in funeral benefit for foreign worker, maximum benefit payment of 7,500 ringgit will be provided, including the cost of repatriation of the remains or ashes to the country of origin. If the death and burial only take place in Malaysia, a maximum amount of 3,000 ringgit will be paid. Then, the rest of the benefit is similar to employment injury scheme for employed workers. These differences I explained in employment injury scheme for foreign worker also can be applied for invalidity scheme for foreign worker, while the physical rehabilitation facility and funeral benefit is given, but only due to any cost that not related to the employment. Education benefit also not included in this scheme, while the rest benefit is similar to invalidity scheme for employed workers. Lastly, for domestic workers, benefit offered are the same offered to formal workers, where local domestic workers follow the employment injury scheme and invalidity scheme for employed workers, while foreign domestic workers follow the employment injury scheme and invalidity scheme for foreign workers.
Now, I will be analysing to what extent the Employee Social Security Act 1969 achieved its purpose. The purpose is to provide social security protection to employees and their families against work-related injuries, occupational diseases, invalidity, or death through compulsory contributions managed by SOCSO. Firstly, the law covers most private sector employees under 60 years old, and it also includes foreign workers from July 2024. It applies to employees earning up to 6,000 ringgit per month. This shows that the law is inclusive and continues to adapt to the current needs of the workforce. Secondly, the Act offers strong protection through two main schemes, the Employment Injury Scheme and the Invalidity Scheme. These provide benefits such as medical treatment, temporary and permanent disability payments, funeral expenses, and pension for dependents. SOCSO also offers free health screenings, rehabilitation services, and return to work programs. This proves that the law not only gives financial help but also support overall recovery and well-being. In addition, the contribution system is fair and practical. Both employers and employees contribute, and the use of digital system makes registration and claim easier. This shows that the law is well implemented and accessible. However, the Act still has a few limitations, which is not all workers are automatically covered, such as informal, freelance, or domestic workers. They need to register voluntarily to be protected. Also, the system depends heavily on employers. If employers do not register or make contributors, employees may lose their protection. In conclusion, the Employee Social Security Act 1969 has successfully achieved its purpose for most private sector workers. It offers strong protection and continues to improve over time. However, more efforts are still needed to include all types of workers and to ensure all employers follow the law. Thank you.